this was going on. Thank you, Irish. Not Irish. Smurfs Turf. I knew this is coming up. Let's play it at 1.5 then to catch up. Put our extension on this now as well. This year's. She's a 50 as well. I mean, all these 50s, like, she's a peaceful, yes. Allegedly, yes. Yes. Or maybe it's the same thing. It might be Clark Kent, yes. It's the same jurisdiction, isn't it? Hey, Murph, I had it open. I just forgot about it. I had it on this AUTV2 News. So I had it ready. Full vibe, she wears some bold colours. So what I might do with this one, I might edit from here onwards. So the public can see it. So I know there's not many here watching live. Doesn't matter. Oh no. So yeah, this is I believe this is a civil one. Hearing in the way, civil case involving yes. So this is a civil case. So I'll be streaming this from now on. Oh, Spider Girl, yeah. Oh no, this is 8 hours in front, so it's okay. It's okay. I can do it. It's okay. So we'll have this on tomorrow as well. But I'll do it open for everybody then. But the sun always shines on the cool. Okay, yeah. So we're definitely gonna be streaming this. If you're not a member, obviously sorry. Well, no, you all are because you're here, but those are not a member, then stop being stingy, buy a bloody membership. You can watch it with me then, huh? Remember, you member. Come on. Right, let me. Oh, here he is, Judge. Oh, there's no boy skipping. He's coming on. So yeah, I'll be showing this tomorrow as well. Let's see if that's Clark Kent though.
We're here on 220500076. Kouri Richins versus Katie Richins Benson in her capacity as trustee of the Eric Richins Living Trust. Got counsel for Kouri to make your appearance.
Thank you. Sky Lazario wants to make
Very good. Welcome. And for Ms. Richins Benson, please.
Yes, Your Honor. James Tracy and Jacob Gornish for defendant Katie Richins Benson in her capacity as the trustee of the Eric Richins Living Trust.
And Ms. King.
Deborah Chan on behalf of the minor children.
Very good. All right. We're here on 3 motions. They are related. So there may be some going back and forth as we address related issues.
Don't know.
Why don't we handle the motion related to plaintiff's 7th claim for relief first? That's the motion for partial summary judgment related to the Oil Transfer Act. How best to start here? Mr. Nader, are you going to talk on this one?
Yes, Your Honor, I am.
I'm going to start with you. I think for the benefit of our media members, you need to stand before you.
Happy to do so, Your Honor. Hopefully that doesn't slide down.
May I ask you a couple of questions?
Yes, Your Honor, please do.
First,
Oh, it's not him.
The fact that a transfer or orbital trust doesn't put assets beyond breach creditors affect the application of the act. Hold on a second. Okay. Let me check with Richard.
Oh, do you like him?
Okay.
Do you like him, Murph?
How is it? I mean, the argument, right?
This is not Clark Kent.
It's as if the assets weren't transferred from a creditor's perspective. They're still reachable under Utah code. What's the act?
So I think there's 2 ways to address that, Your Honor. And the first is, with and of course, as you mentioned, there's bleed over into the other motions that are issued. And I think this particular issue, lends itself to that specifically. because one of the positions that the defendant has taken in this case is that Eric no longer had anything to convey to.
Oh, shut the front door. Hang on, people. That's annoying.
I want to make sure that was clear for the record that after the disallowance, we did file a lawsuit just simply under the statutes of the trust code. Then yeah, I think we would agree with you that unwinding the transfer may not be necessary, or we may not even need to get there.
Can you hear all right?
If Kouri is in fact a creditor, and I think that's a critical question here, and is admitted in the opposition that if Kouri is a creditor and therefore has a claim for purposes of the statute, then really there's no need to go through this process of dealing with a voidable transfer because there's a much more direct way of going about it.
I agree there's a more direct way. I think you may be reading too much into their concession. I read their brief as saying we can see that she falls within the statutory definition of a creditor, not that Eric Richins had a business interest to transfer at the time of his death. He already transferred it in a way that doesn't breach the prenup.
Right, and I don't want to correct. I don't want to say what their position is or any. I'm sure they will look it up here. I do think they do dispute that Kouri's a creditor, though. In the briefing, I think they dispute that there's a creditor-debtor relationship that existed here under the underlying documents and the claims that have been asserted. It's very clear a creditor is an individual that has a claim. The claim is defined very broadly under the Act. So we think, as a matter of law, Kouri is absolutely a creditor under the Voidable Transactions Act. And
but given the breadth of the definition of creditor, isn't it true as a matter of law that you can be a creditor by virtue of an allegation rather than an adjudicated fact, right? I mean, that's
correct. Right, exactly right. I mean, the statutory language says it can be a disputed, unliquidated, contingent, right to payment. So yeah, clearly we say that Kouri is a creditor under these circumstances. But with respect to my recollection is that the position that transfer to a revocable trust can't constitute a voidable transfer for purpose of the Act. My recollection is all the case law is foreign case law, nothing that would be specifically binding on this court. And at the end of the day, we cited a case law, which I will mention as well, is from an outside jurisdiction, but we think it's illustrative that these types of revocable trusts can be used as an instrument to do exactly what what the Voidable Transaction Act seeks to avoid, which is to put things outside of the reach of creditors under that very broad definition. And specifically the Pandy case from Colorado that we cited, again, recognizing that it is not binding on this court, but it specifically addresses the idea that a debtor should not be able to have all the benefits associated with a revocable trust to the detriment but be able to shield that from all the creditors.
But if I read the Utah probate code correctly, there is no limitation on the post-death susceptibility of an asset that's contributed to a revocable trust during the testator's life to claims of creditors. It's as if it was just sitting in the estate of the individual, right?
I think you're correct, Your Honor.
Okay.
Yes.
So I think their argument was categorically, as a matter of law, transfers to a revocable trust cannot be within the purview of the Act. Now, in fairness to you, they're not in the purview of this section of the Act. Well, what about the no equivalent value? Would you acknowledge there's an issue of fact as well? $2 million is equivalent value. I don't know that I can grant summary judgment on that.
Could you clarify your question? An issue of fact on the value on that value, or
There's two different sections of the Act.
Right, correct.
Two different things. We'll say silos of the Act.
Right.
One is creditor-debtor transfer with the intent to hinder related fraud. That'll be category number one. Then there's a second category of creditor-debtor transfer, not for equivalent value, substantial value.
I think it's reasonably equivalent value.
That would not be affected by the assignment, right? Or is that would not be affected by this argument related to categorically putting in a revocable trust? That's a separate issue, right?
Great
Right.
beard.
I think so, yes.
But here you are asking for summary judgment, meaning undisputed facts, ruling as a matter of law.
Look at that. Look at the side of it. Look at this. It all ties in nicely. Look at it. It's just all trimmed to say he knew he was coming on TV. He's done that. Oh, fair play to him. He looks gorgeous. Fair play.
Was in fact a voidable transfer. In order for me to rule in your favor on that second category of argument of the Act, I would have to rule as a matter of law $2 million wasn't enough. Right.
So that the $2 million was not. So let me make sure I understand your question, Your Honor. So under Section 203, I think is where we're operating. This is the second group, right? In order for a transfer to be voidable, there needs to be. In fact, do you mind if I just pull it up? That might be the easiest. I don't want to misquote it here.
I'll go tickler.
Assuming my technology work. There we go.
You ladies must be starting to get wet now. That is beard. That'll be a wet beard before long, won't it?
So 202 is actual intent to hinder, delay, or defraud, and 203, subsection 1, is that it transfers voidable if the debtor made the transfer without receiving a reasonably equivalent value in exchange for the transfer, and 2, the debtor was insolvent at the time or became insolvent as a result of the transfer.
And what I see them saying is myriad issues of fact. You haven't proven it based on undisputed facts as a matter of law. What's your response to that?
Our response is they haven't provided any evidence any admissible evidence to the contrary, right?
If you have the initial burden here of production, which they're saying you haven't met it, tell me why you haven't.
I think we met it, Your Honor, because first we have the testimony of our client as to the assets that were owned, that she was aware of at the time of the transfer. In addition, we have the additional debts that we know existed. I don't think there's any dispute as to at least the first mortgage debt. Certainly, there's a dispute as to the second one right now. But even if you disregard the second mortgage, with respect to the first mortgage, they haven't identified, or we have come forth with evidence, testimony from our client, stating that Eric's assets did not exceed $200,000, but that his debts did exceed $200,000, and we have that demonstrated by solely the amount of the first mortgage on the house, right? So with that testimony and providing, the fact that that debt existed at that time, we think we've met our initial burden to demonstrate that those were the amounts of Eric's assets, those were the amounts of his debts under the terms of the act that constitutes insolvency, and therefore.
Run those numbers by me one more time. I didn't hear you say the words $2 million.
Correct. I did not say the words $2 million. And I think here, because the focus is on the debtor receiving a reasonably equivalent value. So that would be Eric receiving value, not the trust, right?
Your entire argument, though, that he as trustee and he as individual are one and the same for the purposes of this analysis. And so if he as trustee is going to receive $2 million from buy-sell, he as individual receives it as well.
To a degree, yes, Your Honor. I don't know that we would say that it's, yes, we think functionally it is one and the same. But again, we are taking the arguments that we've received from the other side that there is this distinction here, right? And so, had the position been taken that, or without the initial position that the fact that Eric did not have, possessed, or own this upon his death, if that position was not taken, it's highly unlikely we would have brought this motion in the first place.
There we go. Let's talk about the prenup for a second. I understand your argument to be by executing the assignment, Eric breaches the prenup by effectively diluting Kouri's interest in buy-sell proceeds by 75%. Right?
Correct.
Could Eric have sold his interest during his lifetime in C&E for $500,000 without breaching prenup?
I think he probably could have, and I think that's where the distinction comes into play. I guess to clarify my previous answer to your former question is we haven't alleged necessarily that it's a breach of the prenup in this case yet. I think the argument is more that irrespective of Eric's transfer to the trust, the prenup remains binding and therefore is still enforceable against the trustee of the trust.
Well, but if the answer to my question is he could have sold his interest for $500,000 without breaching prenup, how is that different than what he affected by the assignment and buy-sell?
I think with respect to the assignment, the distinction here is that if he just went ahead and sold it to a third party, then you have a third party purchaser who, presumably took for value, took for consideration, and therefore would have all the defenses and rights associated therewith. Frankly, if it was sold to a third party, I don't know that our argument remains the same or stands here today, right? Under these circumstances, though, Eric essentially.
Right, let's be a good host. Kouri Richins, she's allegedly from Salt Lake City, allegedly alleviated her husband. She then wrote a book for children because she has 3 children, and she went on TV and everything, and she wanted to write a book, to help children understand what grief is. And she said there weren't any books out there for that sort of thing, but there was. This is the civil aspect of the trial, the civil trial, with the family suing her. She basically, the very next day, so it's a long story here. She tried to apparently kill him a few times, but she only succeeded apparently, allegedly, when he died. He'd already told his sister that he thought that she was trying to kill him. He only stayed with her for the children's sake. She wanted to buy. She was a realtor trying to make houses up, do them up. Um, she wanted to buy a $2 million house. He did not. He died that day. The very next day, she bought a $2 million house. So now we go in. Yeah, she was poisoning him. So they went on holiday once, and she poisoned him. He went straight to the toilet, and I think he spewed it up, so it was fine. But I think she's tried to do it a couple of times. So that's the gist of it. Obviously, this is the civil aspect of it now, and I'm not 100% sure what this is all about. That's why they're discussing it now. Law looks like, well, put it this, C-Swept, right? The chat, once the judge came in, the chat all went quiet. I think, I'm just guessing here, I think these ladies, they went upstairs, got the drawers open, got the vibrators out, and that's why they're quiet. I'm just allegedly, that's what they're doing. So, but he is fit. I will give him that. He's a fit judge.
Transfer the interest to himself as a trustee, right? So it's different. Our position is different and distinct than a sale or a transfer to some sort of a third party.
Well, he transferred it to himself as trustee, pursuant to an agreement that maintained an interest in Kouri, albeit 25% of which he had beforehand. But if he can choose the sales price, how is it effectively different?
And I guess I'm not sure. Could you explain the 25% versus 75%? Maybe I'm missing
There are
something.
4 beneficiaries.
Okay, understood.
That table's version of it. There's
Gotcha.
1 under yours. There's $2 million at stake.
Gotcha.
Sell it for $500K. Why can't he do what he did?
Again, it's a fair question, Your Honor. And I think it's not necessarily in terms of what he could or couldn't do, but the fact that he transferred it to the trust or himself as the trustee, and the prenup specifically imposes those rights and obligations to successors and assigns. And so in that capacity, we would say that it's still enforceable as to the defendant in this case.
Could Eric have donated his business interest in C&D during his lifetime to a charitable organization? Come to the conclusion that, you know what, I'm done working. This has been great. I'm going to go beyond the I'm going to donate my interest in C&E, this thing I worked so hard to build, to the church, to the nonprofit organization that maintains open lands for hunters and fishermen. Could he have done that?
I think potentially he could have. Do I think that there are still potential claims that arise therewith? Yes. I mean, it's difficult to.
What would the claim be?
Well, I mean,
It's his sole and personal property by the 4 corners of the prenup. He can do whatever he wants with it during his lifetime. Right? If it increases in value, he has no claim to that increase during his lifetime. I guess what I'm trying to ask is, why doesn't that give him the full authority to alienate it during his lifetime?
right. And again, I think it's a fair question, and it's difficult to state in these hypotheticals, particularly when, given the amount of work that's gone into this business, the idea of donating it to a charitable contribution, sure, it's possible, right? But again, at the end of the day, we think it comes back down, if you look at the plain terms, yes, it is unequivocally during his lifetime, it is going to be his sole and separate property with this single contingency, correct? And we believe that contingency occurred in this place, and that the transfer to the trust, and the effective transfer to himself, perhaps may be the only circumstances where we would be bringing the claims that we're bringing, but don't think that undermines the validity of those claims.
Okay. I understand.
Thank you, Your Honor.
But these people not see further.
Yes, Your Honor.
Start with the last issue. Well, actually, no. Start with the vocal transfer.
The voidable transfer?
Yeah.
Well, Your Honor, we agree that the problem with the voidable transfer, it doesn't fit the facts of this case. It doesn't fit. A voidable transfer is a remedy for creditors to get at assets that debtors have tried to put outside their reach. As you mentioned, and we've cited in 75-7505, it's very clear under the trust code that assets held in a revocable trust are subject to the claims of the creditor during the grantor's lifetime.
What about the section 203?
Well, so 203, now that, and I do think it's important to look at the difference between section 202 and 203. To remind ourselves, on section 202, that's where you have a claim that arose either before or after the transfer. I don't see how Kouri could have possibly had a claim before the transfer, but we could talk about that.
Prenup was in existence before transfer.
Right, but what claim did she have?
Well, it would be a contingent claim that by this transfer, you are undermining
Okay.
that which you agree to in the prenup. Now, we have a whole colloquy I just got into it today about the fact that you could have done it anyways, but
Exactly.
the act provides a different overlay.
It does, but I think it's an important point to talk about whether she was a creditor, whether she had a claim. And if so, was her claim before or after the transfer? I think that, and we do take the position that she wasn't a creditor, she didn't have a claim. But let's take your hypothetical. Before the transfer to his trust, let's say he sells it for $500,000 to a third party. Does Kouri have a claim?
Maybe the 500K, I think that's what it's
Well,
that's traceable at this point.
The question is, though, did he breach the prenup? And I think, as Your Honor noted, he could have done anything with it. So our position is there was no breach of the prenup because Eric wasn't obligated to keep it in place for her. If Kouri was worried that he might do something like sell it, she could have negotiated that as part of the prenup. She didn't.
But in fairness, and without naming names, I'll give you an example. Let's call it a divorce case in Summit County. Husband transfers an asset to a third party, gets a divorce, reacquires the asset. It looks like a sham. The act applies to that situation.
Absolutely.
And
If you can meet the
that's
elements.
the case, why wouldn't, we can't say that the act applies, doesn't apply categorically. If, for example, staying hypothetical here, Eric transfers his business interest in C&E to a third party for $100 or $1. After his death, his estate, the trust, maybe his kids reacquire it for $1. Starts to look a little more shaky. And so that didn't happen here, by acknowledge. But in terms of trying to determine whether or not the act can apply to this case, why don't we have to contend with section 203?
Well, let's look at 203. We don't think she's a creditor under 202 or 203. And the reason is because the prenup did not restrict Eric in any way from disposing of his asset, and that governs. If he had disposed of it, she wouldn't have a claim. So we don't think she's a creditor. That's our position. But let's look at 203. 203 applies for claims that arise before the transfer, not after, and if the transfer was done without reasonably equivalent value and you're insolvent. Well, first of all, when you make a transfer to your revocable trust, well, and particularly in this case, the trust says all of those assets, every penny, are available for Eric's use. They cannot show it wasn't for reasonably equivalent value, because if he had, by the way, what did he have? He had a business that's worth at least $2 million. He has a house that's worth $1.7 million. The first mortgage was $260,000. The second mortgage, which we think was fraudulently obtained with fraudulent powers of attorney, was $250,000. But even if you take those together, that's $500,000 on a $1.7 million house. Plus, Katie filed a declaration that says he's got other funds, stocks, vehicles. I don't think this is a close call on solvency, but they clearly can't meet the burden of proof on insolvency. But in any event, Your Honor, there's clearly, if you take what we just talked about, $2 million for the business, $1.7 million for the house,
Yeah,
maybe $250,000 for a mortgage, you're well over $3.5, potentially $4 million. Every penny of that in the trust is available for Eric. How can that not be reasonably equivalent value? It went from one place where he could use it to a trust where he can still use it.
So in terms of the ruling you request on plaintiff's motion for summary judgment on your 7th claim for relief, you did file a cross motion.
We didn't.
Is it just deny the motion, or is it rule as a matter of law that transferred or revocable trust is outside the purview of a 202 claim and deny the motion?
Yes, the latter, Your Honor. As it goes in summary judgment motions, you may not file a motion, but if the ruling comes down, it's law of the case. It effectively disposes of the claim. And so, yes. Yeah, so we don't think she's a creditor before or after the transfer. We certainly don't think there's any actual intent to delay, hinder, or defraud, because the assets are there available to creditors during Eric's lifetime. They can't show that it was without reasonably equivalent value, because all of the assets that were there before were still available for Eric's benefit, and they can't show that he was insolvent. In fact, it looks like he wasn't insolvent. He was solvent by somewhere approaching $4 million on the plus side. So for all of these reasons, we think that the summary judgment motion on voidable transfer should be denied.
Okay. Talking about the interplay between the terms of the prenup and then the events, buy-sell agreement in June 25, 2019, and the assignment in February 2020.
Okay.
Your position, I think, is you do everything.
He can do whatever he wants. I don't know that the prenup could have been more clear on the fact that this was his, not hers. No part of it was hers. He could do anything he wanted with it. That seems to be crystal clear. Then we get to section 2, sub 1, under the title separate property of husband, that says the expenditure of commingled marital funds on said business. Because they're thinking, well, what if you spend commingled funds? The expenditure of commingled marital funds on said business shall not give wife a claim or right to an interest in said business, or alter the separate ownership of said business, except that if husband should die prior to wife while the two were lawfully married, husband's partnership interest in said business shall transfer to the wife. Well, Your Honor, Eric simply did not own a partnership interest at the time of his death. It was owned by the trustee of his trust in his fiduciary capacity. It so happened that he was the trustee of his trust, but legally that makes no difference. The business interest was not owned by Eric individually when he died. It is not a distinction without a difference. It is a distinction that the Utah law recognizes. If that business interest had been owned by him individually when he died, that would have had to pass through probate. It did not. Nothing in the prenup restricted Eric's ability to sell, transfer, or assign his interest before he died. And again, the prenup makes clear that the membership interest was Eric's sole separate property to do with as he pleased. It seems to me, Your Honor, what Kouri wants is the court to ignore well-established principles of trust law that allow someone to transfer legal title to assets from themselves individually to a trustee. Your Honor, it wouldn't, let me use an example. If Eric, instead of transferring it to his revocable trust, had decided to create a limited liability company, Eric Richins, LLC, and he's the sole member, would we be having this discussion? Maybe. They would have to say, well, okay, but what would they have to do to get there? They'd have to say, well, for that, you can just Your Honor, just ignore. You have to ignore the corporate structure of the LLC because he's a single member. Well, that's not the law. An LLC is a separate legal entity, and the law recognizes it as such. It's really not much different with a trust. A trustee of a trust holds the legal title for the benefit of the beneficiaries. Real property. And in fact, in this case, the real property transferred from being owned by Eric to being owned by the trustee of his trust. Again, the fact that he was his own trustee doesn't make a difference.
So when I look at the list of relief you're asking for, I think it's different than what you're arguing in favor of. It seems to be what you're arguing in favor of is a ruling as a matter of law that the
He's a separate person.
assignment by Eric and his business interests to his trust in February 2021 was affected. It was not a breach of the prenup. Full stop.
Yeah, I'm a little bit.
Yes, but footnote.
Yeah.
Even if it were a breach of the prenup, who's your claim against? It's not against the trust. It would be against Eric. And I'm here to tell you, Your Honor, they have not brought a claim against Eric Richins for
Well,
breach
no,
of the
I
prenup.
think what they're saying is the assignment is
Yes.
valid because he didn't have the authority to do it because he already agreed and they were
Well-
going to hold some interest or hold going business.
Well, Your Honor, Having an assignment or a contract or any other agreement not be effective is a completely different story than breaching it. There's no suggestion that it's not effective. It could be a breach.
Pause for a second. You keep taking on more water than you need to, and I can understand why. For example, you're asking me to rule that the trust proceeds shall be distributed in accordance with the terms of the trust agreement. Lord knows what kind of equitable or other fiduciary duty arguments are sitting out there. Why would I make that ruling today? Isn't the only thing that's before me today is, does the trust hold the $2 million? Period. Or is, no, the $2 million is his estate.
We are perfectly satisfied with the ruling that the trust owns the $2 million.
And then the parties litigate whatever arguments they have beyond that after that, right?
Fair enough.
By the briefing, less than the introductions to the briefs, I think that's the proper result today. You see it differently.
No, we'd be satisfied with that result.
Okay. All right, let me hear from history.
Yeah.
I was not a party to this when these briefs started, so I will keep it short. There is an extra avenue I think we need to look at, though, the facts of which have arisen since the original briefing. And it's this. Eric died on March 4th, 2022, and under Utah Probate Section 75-3-803, Kouri had a year from the date of his death or 60 days for receiving written notice or notice of publication to present a claim to the estate. While she did initially timely file a notice of claim in the estate case, that claim was solely based on the allegations made in the trust complaint. There are no personal allegations against Eric. These claims were then disallowed by the PR on April 12th, 2023. Utah Code Section 75-3-804, subsection 2 requires that a proceeding be commenced within 60 days after the personal representative has mailed the disallowance of claim. To date, there is no proceeding that's been initiated and the time to do so has passed. So,
This has not been briefed.
It has not, Your
I just wanna
Honor.
make sure I understand, to see where things are headed. So,
if Kouri doesn't
the
have
moment Eric dies, right, the business interest, the buy-sell proceeds, which have not been liquidated yet, are coming, are either in his personal estate or in the trust.
yes,
Your side of the room says in the trust.
they are in the trust.
The trust gets administered according to his terms. Kouri doesn't have to make any claims. Right?
Or in the club.
She does have to make a claim if she's going to contend a fraudulent transfer because Eric has to be the debtor. So, on all sections of
But if it's in his estate, this is where you're telling me these deadlines with harsh results.
that's correct. If she didn't make a claim but in the estate and pursue it within 60 days of receiving that notice of disallowance, those claims are now barred.
And when you say claim, is that her argument under the act?
It would be a claim that she has any claim against Eric, right? Whether it's breach of the prenuptial agreement, breach of the duty of good faith and fair dealing. So without those, a claim on that she owns half the house. Without those, there can be no debtor-creditor relationship, Your Honor. And every section of the Utah Voidable Transaction Act requires a debtor-creditor relationship as a predicate to asserting the claim.
With the push on slide here, I'll understand if you know.
Yep.
This is new and not going to make any rules on this today. But if the house is in trust, we just apply the trust, right? Subject to acknowledge there's a Slayer statute issue sitting on there.
She can make a claim as to whether she's a tenant in common with the trust.
Right.
But to the extent she has some claim against Eric as a debtor, she's lost that.
You're going to have to brief that. We
Okay.
can't rule today.
That's fair.
Talk to me about the arguments that were anything out on this.
I think that the argument, there's a valid transfer here. To the extent that that transfer did something that the prenup, I think on the face, the prenup allows for that. To the extent that that violated, I think the only issue would be a duty of good faith and fair dealing as to Eric or some other frustrates the purpose of the contract. Those claims were against Eric personally, and they need to be brought against him personally. I don't know if you can, I don't think that claim goes against the trust because the trust would be the same as a third party transferee for purposes of this. She didn't have a vested interest, and Eric could do what he wanted with this. And so when he transferred it to the trust, it was a valid transfer. It sits in the trust unless she can avoid it somehow. She can't avoid it through the Fraudulent Transfer Act because she's not a debtor.
Because the condition precedent hasn't kicked in yet.
Because, yes,
But the
Because-
definition of claim talks about contingent claims.
can't be contingent. At best, she had a contingent unliquidated claim that can now never be liquidated because it's time barred.
Okay, I agree with this.
Yep.
All right, let's just go over this one more time here. Mr. Nate,
Can I just say 1 minute, Your Honor, very briefly?
Sure.
Is that okay?
Yeah. take it home. You take this one easy.
I'll keep it brief. So just with respect to the argument that was just made, the claim was disallowed, and then we did file a lawsuit against the estate. That is case number 230500230. It's also in front of you as well. Has not been served yet, but that action has been commenced, and in order to preserve, the claims that have just been served. So I want to make sure that was clear for the record that after the disallowance, we did file a lawsuit within the statutory time period.
Anything else?
No, that's it. Thank you, Your Honor.
Mr. Tracy?
No, Your Honor, as far as the issue about the claim, I don't think that's before the court today. We'll deal with that in the other case, I think.
So yeah, I don't really know what's going on now.
Procedural posture of today's hearing bears noting. We're here on 3 motions for partial summary judgment. No matter what I do today, it does not dispose of all claims between the parties. There will be more litigation after today. With respect to plaintiff's motion for summary judgment on plaintiff's 7th claim for review, which requests a ruling as a matter of law that Eric Richins' transfer of his assets into his trust should be avoided, and that Kouri is entitled to exercise any and all remedies, including those available to Utah's Avoidable Transactions Act with respect to those assets. The motion is denied for the following reasons. First, with respect to the portion of plaintiff's 7th claim for relief that is brought under Section 202 of Utah's Avoidable Transaction Act, the court rules as a matter of law that because a transfer into a revocable trust does not place assets beyond the reach of a creditor, that a Section 202 claim does not apply as a matter of law to a situation where assets have been transferred into a revocable trust. Second, with respect to any portion of plaintiff's 7th claim for relief that is asserted under Section 203 of Utah's Avoidable Transactions Act, the motion is respectfully denied because plaintiff has not yet carried her burden of showing through undisputed facts supported by evidence in the record the insolvency and or failure to receive reasonably equivalent value elements of that claim. Therefore, plaintiff's motion for summary judgment on 27th claim for relief, docket 241, is denied. Plaintiff's motion for partial summary judgment, which is docket number 7, and defendant's motion for partial summary judgment, which is docket 249, are related. Plaintiff asked for a ruling as a matter of law that Kouri is the sole legal and equitable owner of the business interest, otherwise known as the $2 million in buy-sell proceeds, that the trust holds no interest, right, or title to or in the business interest, and that Kouri is the sole and proper recipient and owner of the business interest and any proceeds that are derived from the liquidation of that business interest. Again, $2 million in buy-sell proceeds that are currently being held in the court's trust account. Firstly, defendant seeks a ruling as a matter of law that sees operating agreement prevent transfer or pledge of the business interest, that the prenuptial agreement with its attempted pledging of the business interest is unenforceable, that the assignment that occurred in February of 2021 is valid, binding, and operated to transfer the business interest to the trust, and that the trust is entitled to receive the proceeds from a sale of the business interest, after which those proceeds shall be distributed in accordance with the terms of the trust agreement. Based upon undisputed facts in the record, the court rules as a matter of law the plaintiff's motion for partial summary judgment, docket number 7, is denied, and defendant's motion for partial summary judgment, docket 249, is granted in part and denied in part as follows. The court rules as a matter of law that the assignment of Eric's interest in C&E in February 2021 to his revocable trust is valid and operated to transfer his interest in C&E to the trust. Moreover, the court rules as a matter of law that the trust is entitled to receive the proceeds, that is the buy-sell proceeds of $2 million related to that business interest. The defendant's motion for partial summary judgment is otherwise denied.
Would you like us to compare to our Your Honor?
Please. Mr. Nate, the motion is to stay. I appreciate your email. How do you want to handle this?
Your Honor, I think we are in discussions, but I think we're close to reaching an agreement. It would be helpful, though, if we could get something on the calendar down the road, just in case those discussions fall apart.
There's another summary judgment hearing coming, isn't there?
In this case,
No, we have summary judgment motions pending, but Your Honor, stay those until we have this hearing.
Is that it then? So that's it then, basically.
Well, this has been ambiguous, but my calendar shows we get a hearing October 18th at 1:30 p.m. in case sitting 049. Does that be safe case?
Nothing more than that.
17076.
What's that?
is that a criminal case?
Yeah, that's it then.
Hold on. I hope I'm not embarrassing myself real estate.
We think that's an unrelated case.
Maybe so. Yes, you're right. My apologies. A lot of Richins in I apologize for that. Okay, Mr. Nate, to your point, I'm going to let you folks talk for another week or two and then tell me whether I want to put a hearing on the calendar or not. I am cautiously optimistic you'll be able to work it out. If you're unable to, file a request to submit. Tell me what you're asking for. I'll work in.
Yeah.
Fair enough.
Mr. Tracy, no objection.
No objection.
Ms. Chandler. Okay. What are the case management deadlines that remain in this case?
Well, yeah, to that point, Your Honor, we've agreed that while we're negotiating on this stay, that we're going to extend the fact discovery deadline out. It's currently the end of this month, but we'll come up with something that makes sense and kind of depends on what we agree on the stay.
Yeah. Yes, Erin, cheers.
Mr. Tracy, anything else?
No, thank you, Your Honor.
He's skint.
Counsel, wishing your clients the very best. Please take care. Court's recess.
All right.
Thank you, Judge. That was a very good judge, I think. Very good judge. If I knew it was that short, I would have just played it normal speed. I don't know who these people are. Wilson with director. Well, good.